You spent that amount of effort planning your wedding, right? I think you should also plan, put that amount of effort planning your divorce as well to end things in a good way. Hello everyone, my name is June. I am the founder and managing director of Eden Law Corporation. It's a Singapore disputes law firm and with a particular focus in the area of family law. And I've been a family lawyer for 16 years. Helping families walk through tough times is my greatest privilege and joy. So with Malaysia as our closest neighbour, it's no surprise that family lawyers in Singapore, we receive a lot of inquiries and handle many cases involving couples who are both Malaysian nationals, or at least one spouse is a Malaysian national. There are also spouses who intend to return to Malaysia after the divorce with their children, or those who have properties in Malaysia that need to be divided in the divorce proceedings. So that's really no surprise because I think 1.13 million Malaysians have migrated to Singapore as of 2022, and with 500,000 Malaysians working and possibly living in Singapore. So there are many of these sorts of cases. And because of these Malaysian connections, these couples do come with some preconceived ideas that are surprisingly culturally different from divorces involving Singaporean couples. These cultural differences are what we hope to explore in this series of videos. And to help me out, my good friend and sister across the Causeway, Ms Kee Hui Yee.
Hi, June. Hi, everyone. My name is Hui Yee. I'm a partner at Kanesalingam Co. We're based in KL. I'm originally from JB. If that helps. And my firm does general litigation. I personally am shifting focus to family matrimonial disputes, and I also do some human rights matter as well.
Okay, so let's dive right in. So maybe I explain a little bit about how it works in Singapore. So in Singapore, divorces are divided into two stages. Stage 1 involves the reasons for the divorce, from adultery to mutual agreement, so we have 6 reasons. And stage 2 involves the ancillary matters, so children, division of matrimonial assets, and maintenance. So statistically for us, about 2/3 of the divorces that are filed go on the simplified uncontested track, where parties can expect the process to be completed within 4 months. The remaining 1/3 of the cases are filed on a contested basis, but will proceed on a mediation track. And most of these cases are also resolved through settlement, with only below 10% that are really, really contested and proceed to hearing in court. So maybe Hui Yee, you tell us, how does it work in Malaysia?
Yeah. So I think in Malaysia, generally, we say there are 2 routes. So one is what we call the joint petition. The other one is the contested petition, or some of the lawyers will call it the single petition. So joint petition is sort of like the easiest, fastest, and the most cost-effective way of resolving a matrimonial dispute. Basically, you agree to the terms of the entire divorce, including whether you want to divorce or not, and how much is the maintenance for the child, spousal maintenance, and of course, the custody of the child. So if you can agree on all these terms, then both parties can file a joint petition, and it will be quite a simple process. Both parties have to sign some court documents, and then the court will fix a hearing date, and then you appear before the judge, and you will get your order. However, if one of these items or terms that cannot be agreed on, then one party can go ahead to file a single petition. So one spouse will be a petitioner, the other one will be a respondent, and then you will sort of go on a full fight. Yeah.
Okay. So in terms of process, how long would a joint petition take and how long would a contested petition take?
So I can only speak for KL Selangor. Most of our files are here. Because in KL and Selangor, we have one family court each in the High Court. Some of the states, they might not actually have a family court. So the cases are heard in civil court, which means that particular court hears other matters as well. So in KL, Selangor, typically nowadays, if you file a joint petition, you should be able to get a hearing date within 3 weeks to a month. So it's quite fast. However, unfortunately, if you go on the single petition route, it's a long, long fight. if you're talking about, I think recently our experience is that if everything is ready for trial, meaning to say that all the documents are filed, parties have exchanged documents, like literally you are ready for the trial to go to court, you're looking at end of next year, Q3, Q4 for the trial dates, just for the trial to start.
Oh, and not even the decision.
No.
Oh, okay. So that maybe all in about 1.5 to 2 years?
I think 1.5 to 2 years considers very, very fast.
Okay.
And this is also if you are talking about that nobody is going to file an interlocutory application. So there are times parties will want to get an interim custody of the child. There are also it's also very common for the wife and to file an application to get the maintenance pending suit for herself and also for the child. So if all these things are still going on, or if there's some discovery application or whatever, then you can expect a longer delay in that sense.
Okay. So in terms of proportion joint petitions, how many, what's the percentage?
I was trying to look for the statistics. Unfortunately, I do not have the statistics. I think it is, I recall that when we spoke to a judge before, she said in her court, just for like contested petition, she has like 3,000 cases in her docket.
Oh, wow. That's amazing. And that's like 2 years each, right?
Yeah. So because I think the problem is also slightly different from Singapore, we don't have a mandatory mediation. So mediation is entirely on a voluntary basis. And of course, parties can opt for court mediation. There is a court annexed mediation center. Then you go before registrars. Usually there are registrars who will mediate the cases for the parties, or parties can hire or engage private mediators, it can be your family friend. It can be another lawyer, or some of them, they might want to have like a mental health professionals, because ultimately mediation really is to help parties come to an agreement for certain things. This is so that there are hopes for parties to go on the joint petition route. Even if, say, they can't agree on every single items, they can narrow down the issues. Then, in terms of trial, it might be faster in that way.
So how common is it for parties in Malaysia to pursue mediation, whether it's private or court? With your own clients as well?
Usually we will, because I myself, I'm an accredited mediator, so I will usually advise my client to go for mediation and try it out. Of course, depending on the issues. I think, I'm sure you agree with me, I think when it comes to custody, something to do with the children, to me, it's extra harder to convince them, to go on that route. And of course, if there are cases, if it involves adultery, which I'm sure we'll talk about it later, then you need to really try to make your client understand why mediation is a viable option. Like you said, when it comes to separation, divorce, everybody is so emotional. And they might not even want to see the other person ever in their life. So to even give them the idea to say, okay, let's come to this same room and then talk to each other, they might not even want to do that. So we will suggest, I think most lawyers will definitely suggest, and sometimes I don't think the court will direct parties to go for mediation for like divorce matters. They will ask parties, have you tried? Is there a possibility? So in our court, it can also be a judge-led mediation, but the parties have to agree. So you can agree to say that I want the same judge who has done the mediation to continue hearing the matters. However, if you are not agreeable, you can request to say, I want a different judge to do the mediation. Then, of course, the court has to see whether there's any judge who is available to do it. But it's quite common, at least in KL. Yeah.
Okay. So I feel that what I'm getting a sense of is that and there's a little bit of a difference here. The Singapore family law ecosystem tends to be a bit more managed. We have, certain tracks to go on. We have mediation tracks, and so our judges are divided into judge mediators and hearing judges, right? Whereas in Malaysia, it tends to be the mediation process tends to be more decentralized. It's whether you feel like it or whether individual lawyers are going to promote that to their clients or not. Because ultimately, the process in court is a hearing one. It's one that, where you present your evidence and you have to do that. So does that mean that Malaysian couples, right, coming from this kind of background, tend to be more litigious? They tend to come with the mindset that they want to, if they catch their husband or their wife in an extramarital affair, that they are like, okay, that's it, I'm going to fight it out in order to, So would you say that?
I think probably yes. I think when they come to see us, they will always be like, I just want to nail this person down. I think perhaps, like you said, mediation is not even something that has ever existed in their mind. They'll be like, oh, this is possible. So I think this is where lawyers play a very, very big role. You have to perhaps strategize or tell your client, advise your client to say that you don't have to fight on every single details. And then why is mediation an option for us to resolve? But I do understand why some of the clients who might not have had a very good experience with mediators. I mean, it can be both, either private or even the court mediators, because the choice of mediator is so important. Some of the mediators, they might not be trained to do matrimonial disputes. I do not know how the mediators in the Singapore are trained.
We have specific family mediation, so it's quite a culture. It's quite a thing. Actually.
I think in Malaysia, at least for the court mediators, that I know they are trained and they are accredited. But these mediators, they hear or they mediate every single matters that come before them. So they also mediate like commercial matters, civil matters. So I think because of that, some of the clients had told us that they don't understand. It might not be a situation where they are twisting anybody's arm. It's just that the clients don't feel safe. They don't feel like this is helping me to come to closure. So sometimes after the mediation, they might be even more disappointed and say that, okay, this guy is really, really not treating, or the spouse
not remorseful, and therefore
correct.
It just spurs them on to want to fight even more. And the system allows for that. Okay. So maybe that actually helps me to understand a little bit when Malaysian couples come to me, and then they, some of them come with a mindset that they want to fight this out, or they want to, that is maybe because of the background of where they come from, and the system doesn't have that culture. Okay. Okay, so maybe I'll move on to another question. Do you think that legal costs play a role in parties deciding whether they want to go joint petition or single petition? I mean, I'd love to hear from this side of the causeway that I explain on our side.
Right. I think legal cost is definitely a concern. At least this is how I will tell my client. That's how I will explain it. So I will usually tell them, there are two options. And of course, I would say, looking at your case, probably we can, if you can agree on this, if it's only just one item you can't agree on, then we can try mediation, we can try negotiation. If it doesn't work, then perhaps that will be the the last resort to go for single petition. But single petition will be very, very long, and it will incur so much more costs. So I think definitely cost is one thing. And we will also, as lawyers, of course, we also explain to them, I know you want to fight, but what do you have to fight, right? Like, do you have the documents? You can have all the allegations. We know you can say that, oh, he told me this, or she told me this, she showed me this before, but do you have it now? When did this even happen? And so it's a lot of things. Then, of course, if you talk about other things, it's not just adultery, right? Of course, adultery, the typical thing that we think of will be, oh, do you need a PI, your private investigator, and how much does that cost? I don't know what's the comparison like in Singapore and Malaysia, but that's an extra cost. And of course, when it comes to, say, matrimonial assets, there might involve extra costs for assets tracing, especially nowadays. You talk about all the digital assets. We had never thought of it being possible in the past. So if you have your spouse having like a, I don't know, crypto or even other digital assets, how do you even get that evidence? So if you're so certain, you are sure that someone is hiding something, then definitely cost is a concern. Because you have to incur extra cost to get this evidence before you can even stand up in court.
Okay, I mean, for me, I tend to take a little bit of a more different approach. And I think that's because what I'm hearing in Malaysia, it's the time taken and the cost taken for a joint petition versus a single petition is so stark.
Yeah.
It can be 1 month versus 2 years worth of work. Whereas I think in Singapore, because we have certain more structured timelines, the time taken can be not so different. So I would actually tell clients that I know that cost is a concern, but if you don't feel the need to agree to certain terms, if you actually don't agree, don't let cost be the barrier, because this particular agreement has some lasting power, right? It has to last your children through maybe primary school, secondary school, and all that, 10 years even. So don't force yourself to agree just because of that difference of a few $1,000s. So I always tell clients that, you have to be absolutely sure that this agreement, the terms in your simplified uncontested divorce, is something that you are agreeable to, you're comfortable with, you think that is a good arrangement for your children, right? Before you go into it, and don't just think that it's because there are simplified uncontested divorces going out there for like 999, 1399, Singapore dollars, of course. But I'm just saying that don't get it's not, you're not buying you're not buying mangoes in the market. You're actually planning for your life, right? And don't just because of that amount of money you agree to something that you're not happy with, because I tell you, ultimately 2 or 3 years down the road, you'll spend money coming back to lawyers, right? Trying to fix the agreement that you got into. So I actually always tell my clients that maybe you want to think about filing it contested, because even the mediation process, I would say roughly about 6 months. And you have the opportunity of going into the court mediation system where there are trained professionals, so trained counselors, trained judge mediators, to help the both of you to iron out the small parts that you are not that happy with, that you are unable to talk to your spouse about. So we totally understand that there are certain things that, you just feel like, I don't care. I just want to, put a closure to it. But no, you put a cap on it, it's just going to come out somewhere else.
Yeah. I totally understand what you're saying, and I can share something that we've encountered before. I'm sure it happens in both Singapore and Malaysia. We have all these, I think ours is not 99 lah. I've heard like 300, 399, 499, 599 just to get a divorce, or sometimes it go up to like 1,000 or something like that. But we've had experience where a client had to come back to us to file a variation application to say that, this term is not defined properly in the court order. It was a joint petition. Then, of course, the court granted the order, what the parties asked for. And then a few years down the road, I think one spouse is asking for more money, and then the other one was like, no, this is not what we envisaged it to be. This is not what we had in mind when we put the term down. So and then of course this person didn't pay, and the other side just filed an application in court to say that you must pay me. And then so it went on for a while, and then the client had to come to see us to say that we had to fight this. And then we inquired and found out that he said, he basically got like some kind of package like this, and then eventually they I don't know how they drafted the court papers themselves, and then someone just went to court for them, and then they just got the order.
Yeah, I'm not really against packages per
Yeah.
se, but I think that you need to understand what you're signing up
Yeah.
to. Yeah, and if it really works for you, you have no kids, no house, and just want to get this over and done with, then okay, fine, no issues with that. But for some people that have a bit more, consideration, right? I think you need to spend a bit more time. You owe yourself that duty to close it off. I mean, you spent that amount of effort planning your wedding, right? I think you should also plan, put that amount of effort planning your divorce as well to end things in a good way.
I think ultimately, everybody should be properly advised by a professional, of course, before you do certain things, because like you said, it's going to last you for so long, and sometimes it's not just you, it is also your children. And of course, then later on, you want to go and say, you want to fund variation to say, oh, this is not what we agree on. You incur more costs and more time. And I don't know how is it like in Singapore, but it's not so easy to change the court order.
Honestly, as lawyers, I don't know about you, but we don't really like to do variations because it's much easier to, as with every contractor, it's easier to put up a cupboard than it is to have to change the cupboard afterwards, right? So because then I have to understand how the cupboard was built and all that, right? So actually a variation incurs much more time and cost than an actual fresh thing. So get it right from the beginning. Okay. So on this note, for Malaysian national couples, right, who have settled in Singapore or they work in Singapore, they can actually choose to file either in Malaysia or in Singapore. So in your experience, how would you advise them?
Okay, so for us, we always look at the issue of domicile. So the issue of domicile will determine where you should file your divorce. And then our law, in simple term, is, I know it's very archaic, it says that the wife's domicile follows the husband. And one's domicile, it's according to your citizenship. Unless it's proven otherwise. So there are situations where this person, perhaps the husband is still holding a Malaysian IC, but then he has gone on to work in Australia or even Singapore for many years. And then does that automatically mean that he has abandoned his domicile in Malaysia? The law says no. He has to really prove that he has abandoned the Malaysian domicile, like he has sold off all his assets, for example. He is literally trying to cut ties or burn bridges with the original domicile. Then you can say that, oh, he's now, his domicile is in Australia. So then coming back to a question, how would I advise my client whether to file in Malaysia and Singapore? I think it really comes down to, of course, the domicile issue, and also where the fight is. It really depends, right? There are situations where most of the matrimonial assets are in Malaysia, and then perhaps you also have the issue of where are the children, and then all these kinds of things. So I don't have a standard answer. It really depends on the each case by case basis. Yeah.
Okay. So I guess they can file either side of the border. It really depends on where the properties or the children are. And for us in Singapore, if you are still a Malaysian national, you would have to prove that you have been habitually resident in Singapore for 3 years before the date of filing.
Right.
So, which is not difficult. If you have an EP or work permit and you actually have a rental apartment, those are the tenancy agreement. Those are the things that I would need to show the Singapore court to show habitual residence. And I guess depending on what your rights are with maintenance or with custody and all that, right, you might then decide to choose to whichever jurisdiction is more favorable to you.
Yeah.
Yeah, but I think you do need to, I do tell my Malaysian national couples that they should get some advice from, this side of the border and that side of the border. Then they weigh, decide which jurisdiction is good to proceed on.
Yeah. So I think if the audience is interested, I think that the whole issue of domicile came up a few years ago in a very, very big case, the Pauline Chai case, Khoo Kay Peng. You can just search on just Google and you'll find the news. And there was a situation where the wife wanted to file the divorce, file the proceedings in UK, and then the husband said, no, you should file in Malaysia. So there was like a big fight. So you can have a look at that.
Yeah, I mean, for us as well, I mean, I think that couples nowadays are quite transnational,
Yes,
international, right? And so a lot of jurisdictions will just come into play when they work and
Yes.
they live. And that is actually an area where family lawyers get to collaborate quite a lot.
Yes.
And that's quite exciting to say, okay, I can collaborate with an Australian lawyer or a Japanese lawyer or Malaysian lawyer. I think that's quite exciting for us as family lawyers.
Yeah, but I think that also comes with nuances and complications, especially when it involves children. You have the issue of parental abduction, you know, and of course, I mean, you don't talk about that's, of course, it's a very, very extreme situation. However, even if parties just want to resolve the matter, again, both parties will really, really have to think very hard where you want to settle down. If you want to move on, where are you going? And of course, your children. Some of them are really young. Where do you want them to go to school? And especially, we have had situation where, someone wants to stay in Asia, but the other spouse, because he or she says that
It's to go back to Europe or Australia.
I have no ties anymore since you are leaving me, I'm leaving you. I can't stay here because I don't have families. I'm not even sure whether I'm going to be allowed to stay here because I don't have a work permit. So what do I do now? So in that situation, if they want to go back to their home country, and then where do the children go?
It's a lot of very hard choices, I would say. And actually this, looping back to our previous point about mediation, that is where mediation actually has its biggest role to play. Because there are no right answers, and it's very, very difficult for a family court judge to look at the evidence and say, and make those hard choices for you. So I would honestly rather that this is where mediation really comes into play. I would rather that both parents, even though they don't love each other anymore, sit down and decide, where their lives are going to be and what works out for them, rather than have somebody else, the judge, decide for you.
Yeah.
Yeah.
Okay. So then maybe I ask you, because you said that your mediation track, it's about 6 months to just do the mediation.
I mean, you will get into mediation by the 3rd month mark, and then you will have sessions, and then you will keep talking, and usually you'll resolve by about the 6 month mark.
Right. But the mediation sessions, are they like unlimited?
Typically, you will get about 3 sessions in court. If there are definitely cases that you get like 7, 8 sessions, and that's if your mediator is super patient. But I think it's for the judge mediator and for the parties to feel, are we making progress on issues? Then we will schedule another session. If you're not making progress, then there's no point, you see.
Right. Yeah. Why I ask this is because do the parties have to pay?
No, they don't if it's court mediation. So for us, court mediation, as long as you have a child below age 21, you will be fixed for therapeutic justice cooperative conference. That's what they call it nowadays, TJCC. And then there's like a whole system, and there are court counselors that are really there to help. And I mean, if you've been to our new family court, right? Like a whole level is just level 3, is just for mediation. That's how seriously we take it.
Right. I think yeah, all right. I mean, I think that's why, like you said earlier, perhaps our mediation here is not as structured, right? Sometimes even clients feel like the mediators are just trying to fulfill their KPIs or whatever, or they just, sometimes when they don't make progress, they just want to give up. And of course, if you engage your own private mediators, it actually works both ways. I think I've encountered both. Sometimes when the clients have to pay someone, they tend to treat it more seriously. It doesn't matter. It's either my client or even the other side. Sometimes, they just feel like, oh, I have to pay for this, so I better sit down properly and think to make my money worth But when it comes to, because it's the same, our court mediation, you don't have to pay.
Yeah.
So sometimes they just treat it like, okay.
And they're not prepared when they go for the
Correct.
session.
They're just there to show. We have even come across situation where the parties try to show that they try because they think by this way they show the judge that, oh, I'm actually a good guy. I try to settle. But whether they've really achieved the real goal is a different story.
Thank you for watching, and we'll explore more topics in the next episode.
See you.